Hello everyone, welcome to Apurva's Legal Bites. Today I am going to discuss the provisions relating to gift under Transfer of Property Act. First, Section 122. It says that a gift is a transfer of certain existing movable or immovable property made voluntarily and without consideration from one person to another person. So we can say that there are two parties in a gift, donor and donee. A person who transfers the property is called a donor, and a person to whom the property is transferred or to whom the gift is made is called donee. And a gift must always be made out of natural love and affection, without any consideration, and freely and voluntarily. If there is any coercion, fraud, undue influence, then the gift will be void. And the property which is to be gifted may be either movable property or immovable property, provided that the property must be an existing one, not non-existing property. Now, a gift is made by a donor to a donee. So it can be accepted by a donee or by his authorized agent, provided that the acceptance must be made during the lifetime of the donor and while he is still capable of giving it. But if a donee dies before acceptance, then the gift will be void. Now, according to Section 123, in respect of immovable property, the transfer is effected by a registered instrument signed by the donor or by his authorized agent and attested by at least two witnesses. Whereas in case of movable property, the transfer is effected either by a registered instrument or by delivery. And here, the delivery is same as that of the goods delivered in case of sale. Now, Section 124 says that when a gift consists of both existing property and future property, then the gift is valid as to the existing property and void as to the future property. So with this, we can say that the property which you are going to gift to a person must be in existence at the time of making the gift. Now, Section 125. When the gift is made to two or more donees, out of whom one does not accept and others accept it, then the gift is valid as to the persons who accept it and is void as to the person who did not accept it. Now, Section 126. Generally, a donor transfers the property as a gift to a donee freely and without consideration. This doesn't mean that the donor can cancel it or can take back the gift whenever he wishes, because the donee will get affected. So we can say that a gift once made cannot be cancelled, suspended or revoked. But however, there are two exceptions to this general rule. First, if there is an agreement between the parties to that effect. Means when both the parties, that is a donor and donee, agree on a condition that on happening of a specified event, the gift can be suspended or revoked. And second, if it is a case where the contract is voidable at the option of the donor. Means if the gift is made by employing fraud, coercion, undue influence, and the gift can be suspended or revoked. Now, Section 127. Generally, a gift is not always beneficial in character. Sometimes it imposes obligation or can create burden upon the party. So, onerous gift is one which carries not only benefit but also burden. So, this section says that when a donor gifts to a donee several things, out of them, few are beneficial and few are burden to donee, then in case of single transfer, the donee should accept both benefit as well as burden. Whereas in case of separate and independent transfer, the donee can accept the one which are beneficial to him and can refuse the things which create burden upon him. Okay? Now, a person who is incompetent to contract is called as disqualified person. And this disqualified person can be a donee for onerous gift. Means if he accepts a gift with burden, he is not liable for it until and unless the disqualification is removed. Means until he becomes competent to contract and understands his burden and accept it, then only the liability arises. Okay. Now, Section 128. Universal donee. He is a person to whom all the properties of the donor have been given, and he shall be liable for all the debts due and the liabilities of the donor at the time of the gift. And last section, 129. When a gift is made by a donor who is in a critical condition which is likely to cause death, is called as donation mortis causa. It's nothing but gift made in contemplation of death or donation made out of death. It is called as deathbed gift. In Hindu law, we call it as a gift, whereas in Muslim law, gift is called as hiba. So we can say that this donation mortis causa and hiba are the two kinds of gifts which do not follow the provisions of TPAct. Means this section 129 is an exception to this chapter gifts. So this is the end of the topic. To know the law in a simplified way, subscribe to my channel Apurva's Legal Bites.